lawyers and non-lawyers who are opposed to Trump have understandably expressed outrage and disgust that the Trump-appointed Judge Alan Cannon dismissed the documents case in Florida, arguing in an opinion that the appointment of Jack Smith as a special prosecutor violated the Appointments Clause of the United States Constitution. That clause is part of Article 2, Section 2, as well as the funding clause contained in Article 1, Section 9. The issue is whether the president had to appoint a special prosecutor who would then have to have the appointment approved by the Senate, and whether Congress had to specifically authorize the funding of a special prosecutor when the DOJ is paying the cost out of an already congressionally approved budget. The justifications for the dismissal are contrary to precedent, but may find support nonetheless among Republican-appointed appellate court judges and Supreme Court justices, with the latter showing little or no regard for past precedent and well-settled law. An opinion written by the Republican Chief Justice William Rehnquist in 1988, titled Morrison v. Olson, the court held that the independent counsel was an inferior officer rather than a principal officer whose appointment was not required to be made by the president subject to Senate confirmation, but could simply be appointed by the Attorney General, who was a principal officer nominated by the president and confirmed by the Senate. The court held in Morrison that the separation of powers doctrine is not violated by a special counsel appointment, even though the president lacked the authority to fire one. Justice Scalia filed the only dissenting opinion in that case, but the current Republican justices, in my opinion, are further to the right than Scalia or almost anybody that's been present in the Supreme Court since the 1920s. Justice Alito has criticized the majority decision. Judge Cannon became the first judge to hold that a special counsel was a principal officer rather than an inferior one who could be appointed by the Attorney General. Cannon was following the lead of Justice Thomas, who issued a concurring opinion in the immunity case, making this kind of argument. As a practical matter, in my opinion, Cannon's dismissal does not change what would have happened anyways when Trump wins re-election, which I expect will happen. Except Cannon is providing Trump important cover by dismissing Smith and the case, rather than Smith being fired and the case dismissed by Trump's appointed Attorney General after he becomes president again. There would be a lot of political blowback if Trump had his Attorney General dismiss Smith early in his term, though the AG might say they had no discussion or he was not influenced in any way by Trump. That would still give rise to another impeachment of Trump, which would include the AG in this kind of example, when and if the Democrats regain control over the House either in 2024 or 2026. From a Republican political viewpoint, it would be better just to have a Republican judge dismiss Smith and the cases. In both of the examples, the AG of Trump's AG dismissing Smith or the Republican judges dismissing Smith, the result is the same. The cases are dismissed, and the documents case would come to an end before Cannon ever scheduled a trial. I didn't expect her ever to schedule one, actually. The government will appeal to the 11th Circuit, whose judges have overruled Cannon's previous rulings on related matters, A three-judge Republican panel reversed one of Cannon's rulings in a matter related to the documents case, finding that it had no legal or factual basis. Even if the 11th Circuit overrules Cannon later this year or early next year, I would expect the Supreme Court Republican justices to reinstate Cannon's ruling, as already signaled by Thomas on this very issue, and Alito also. And that would be consistent with the other Trump-favored opinions involving the creation of presidential immunity for crimes and the Fisher decision, where the Republican justices rewrote the obstruction of an official proceeding statute that just in a way that just happened to benefit Trump. The district court in the insurrection case is likely to reach a contrary result than Judge Cannon about the legality of Smith's appointment, based on an earlier opinion in the D.C. Circuit that the appointment of Mueller as a special prosecutor was not unconstitutional. Hunter Biden may raise the same issue since his prosecution was led by a special counsel. If Trump raises the same argument in the D.C. insurrection case and the district court dismisses the motion to dismiss on the grounds that Cannon dismissed the documents case, the appeal would be taken, and that would delay the trial into the very distant future, even if the decision finding that the appointment was constitutional is affirmed by the D.C. Circuit and Trump loses the election. The delay would give the Republican Supreme Court justices an opportunity to dismiss Smith, and that would end the case as well. So it looks like to me that there will be a total failure of the Republican-dominated Republican federal judiciary to ever hold Trump accountable for his past, quote, alleged, quote, end quote, crimes, and that will extend to all future alleged crimes as well. If Trump loses, which I do not expect, as I said, the Cannon decision may prove to be a win for the prosecution, provided a lot of ifs occur, and those include the 11th Circuit reversing her decision and then removing her from the case, and the Republican Supreme Court justices decide that it might not be politically wise for them to entirely dismiss the charges against Trump by removing Smith after already gutting a good part of the D.C. insurrection case. I would place the odds of all of those things coming together and occurring as very low, practically non-existent. Even if they all did happen, Trump would have his AG fire Smith and dismiss the criminal cases several years from now. I do not expect the appellate court will remove Cannon until she issues another order dismissing the case or excluding material evidence from use at trial, assuming that they do reverse her on the dismissal on constitutional grounds that she just made. There will be no end to her baseless rulings until the appellate court removes her. Those opposed to Trump will simply have to pray really, really hard every day that he internally restrains himself from committing crimes or irrefutably immoral actions unbecoming of a U.S. president. During Trump's second term, internal restraint of his worst impulses, unseen so far in his history as an adult, will be the only restraint left, in my opinion. Maybe Trump has had a come-to-Jesus moment after being almost killed and knowing that he was lucky to survive. Never know. Anything is possible, no matter how improbable. The sun may go supernova tomorrow at 10 a.m. Central Standard Time or on July 18th, 2024 at around 5 p.m. Central Standard Time the Earth may be pulverized by asteroids. The tweet that I'm about to read from Trump that he posted on July 15th, indicates that he has not turned a new leaf. Quote, as we move forward in uniting our nation after the horrific events on Saturday, this dismissal of the lawless indictment in Florida should be just the first step, followed by the dismissal of all the witch hunts, the January 6th hoax in Washington, D.C., the Manhattan's DA's zombie case, the New York AG scam, fake claims about a woman I never met, a decades-old photo and a line with her then husband does not count, and the Georgia perfect phone call charges. The Democrat Justice Department coordinated all of those political attacks, which are an election interference conspiracy against Joe Biden's political opponent, me. Let us come together to end all weaponization of our justice system and make America great again, end quote. For Democrats, in my opinion, the focus needs to be regaining a majority in the House. While that will prove to be difficult, I think, it is the only conceivable restraint that I see that could be imposed on Trump from actually exercising his worst impulses during a second term.